The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Good morning. Court Radio is now in session. Call 215-227-2727. When you've got legal questions, we've got the answers. This is Court Radio. And now here's your host, Dean Weitzman.
Good morning and welcome back. It's Court Radio, and I'm Dean Weitzman, and I thank you for listening. All you got to do is give us a call here. We'll get to your legal issues one at a time. 215-227-2727. That's the number for Court Radio on Sunday mornings, and the number for My Philly Lawyer all week long. 215-227-2727. If you've been sitting on a legal issue, we probably can knock it out of the park today. And I'm joined in the studio. You just sit back and relax. Joined in the studio with my special co-host, the guy you're always looking to call on Monday mornings. It's Saul Langsam.
And a very good morning to everybody.
Hey, Saul. And you know, when Saul's here, we're talking wills and estates, folks. So if you've got those wills and estates issues, somebody passed away decades ago and you're trying to figure out how to get their property into your name, or maybe you want to plan for the future and you're thinking about doing a will or a trust, today's the day. Saul's here to answer your questions live on the radio. 215-227-2727. Before we get to wills and estates, we have some sad news to talk about. As most people probably know, there was a horrific terrorist attack in Paris, France, where over 120 people have been confirmed dead and 200 injured. Many of them young folks who were out watching a concert at the time. The borders to France were closed, and they're dealing with what we here, unfortunately, are all too familiar with. We send them our prayers, and we hope that all of this insane violence comes to an end real soon. There just doesn't seem to be any answers that are going to be found by this kind of behavior. Nobody's safer. Nobody's freer. Nobody has more property. It's just insane, where innocent people's lives are taken for political gain. 215-227-2727. You got comments on France. You got legal issues in your life. Give us a call today. We're going to talk about a bunch of stuff. On another note, Philadelphia has renamed a section of City Line Avenue. The section from Monument Road to Presidential Boulevard was dedicated as the Ed Bradley Way during yesterday's ceremony. Ed Bradley, the famous Ed Bradley from 60 Minutes, started his career in Philadelphia, and we honored Ed by renaming a section of City Line Avenue, which is always a good thing, I think, to kind of bring back to Philly those folks who have made it and kind of honor them in that way. So, Saul, how are you this morning?
Just wonderful. Thank you, Dean.
You know, my car makes me feel guilty. My car actually on the dashboard will tell you the speed limit of the road that you're on. And then right next to that, it tells you your speed limit. And it's like you can't even lie to yourself anymore and figure, like, you know, it's got 50 on the speed limit. And the weird thing is, like, I can enter a work zone, like a temporary work zone where they drop the speed limit down from 60 to 50, and instantly, right at that exact moment where the work zone begins, the speed limit on the car drops down to 50. It's amazing. And, of course, my speed limit coming here today exceeded that just a little bit.
I guess you were flashing 90 coming down here this morning.
I can't confirm or deny the actual speed, but it was more than the legal limit. And thank goodness the roads were empty, really. But, yep, that's what we were doing this morning. 215-227-2727. I'm reading Monica's mind just as she hands it to me. It's coming out of my mouth. You know Monica. She's on the phones. If you want to get your questions on the air, she's the woman to speak to. And try to be succinct. All right? Let's talk to Melissa from Glassboro, New Jersey. Hello, Melissa, and welcome to Court Radio.
Hello.
Is this your first time calling?
Yes.
Are you a little nervous?
Yes.
Okay. Well, just relax. Are you driving or like at home somewhere?
Oh no. I stopped over because I just heard your your radio come on, so I was trying to call and see if I can get a question.
There you go. Well, and you're on, and we're going to make every attempt to answer your question right now. So what's your question?
Okay. This is, the first time I did it. I really don't loan out money, but my friend needed some money. So she was moving into her apartment, so I lent her some money, and I was trying to figure out, what is the, legal advice that I could get to get the money back, because I lent her the money, and she hasn't made any arrangements to try to pay it back.
Right.
And
Can I ask you?
We had agreement.
How long ago did you lend her the money?
It was in August because she was moving in August.
Okay. And what was the deal? Like, what did you two decide you were gonna lend her? How much money?
Well, it was $850 for her to move into the apartment. I was lending her the money, and she was supposed to pay it back soon as she could, because at that time I needed the money, but I didn't want her to be homeless.
Right.
So the agreement was I would lend her the money, and she was going to pay it back as soon as she could.
Okay. So as soon as she could be a week, and it could be 2 years. I mean, I'm not sure how to define as soon as she could.
All right. Well, I lent it to her and she was going to pay it back maybe within 3 to 6 months.
Okay.
It wasn't supposed to be, a year or anything like that.
And have you asked for the money back?
Yes, I asked for it back, and she's like, well, we don't have to go to court or anything because she's going to pay it back. But she claims that she's, going through hard times and stuff like that, and she's looking for a job and all this stuff. I'm like, well, that doesn't sound right, because that's not what we agreed to. And she even had her boyfriend getting in the middle of it. I'm like, well, he has nothing to do with what we agreed to about. We agreed to this about in August. And
right.
So
here, where does she live? Where did you lend her the money?
Oh, in Glassboro.
All right. So, well, here's the answer. I'm not sure you're going to get your money back, but I will tell you how to begin the process is to make a demand of her in writing to return the money as promised, and give her whatever you feel is appropriate, a month or so, and if she doesn't comply with your request, then file a lawsuit in the district court for that area. So you're gonna, you'll go call. You can Google it or call the county or township municipal building and find out where the district court is, because each area has its own district justice. Okay, and you're going to file what's typically referred to as a small claims complaint, and you will sue her. They'll help you fill it out. It's not all that expensive to file, and the clerks of the court will help you fill it out. And then not long after you do that, you'll have your day in court. And maybe she'll show up, maybe she won't. More likely than not, you're going to get a judgment. But now the tricky part is converting that judgment into cash. That's a whole other story for another day. But before you get to the collection piece of it, you actually have to get a judgment. But here's the the side answer, and it's not the legal answer, but it's the real deal. And that is, when we lend money to friends, it's nothing but trouble. I'd rather people just give the money rather than lend the money, because oftentimes, unfortunately, Melissa, is what you're facing is what happens. Friendships end over it, and you never, and a lot of people don't get their money back, because it's not easy to get money back from an individual, who doesn't have much. But having said that, if you want to take matters into your own hands, and I'm not suggesting you shouldn't, you start by filing a small claims complaint in the district court near your house.
Okay.
All right. Good luck with that. Thank you so much for listening to Court Radio, and have a great Sunday.
Thank you, and you too.
That was Melissa from Glassboro. 215-227-2727. The lines are lighting up, folks. You got your questions. We probably got answers. So, Saul, you're here today. Let's start the topic of estates and trusts and stuff of that nature. First of all, my Philly lawyer, do we actually go to court and litigate these matters? Are there times when you actually have to go before a judge, have witnesses, put forth testimony?
There are any number of instances where we find ourselves, if we're retained, proceeding with a claim on behalf of a client. It could be a multitude of reasons why somebody might feel that.
Well, let's be for real here. What was the last matter that you went to court on for one of these disputes?
The last matter was challenging the author of a will document who lacked the capacity to sign a will document at a time where she was determined by her treating doctors to be suffering from advanced dementia.
Okay, so a woman who was suffering from advanced dementia prepares a will, signs it, and gives her property away. She then passes.
Correct.
So who are the people fighting over this property?
Well, it's usually the heirs, the beneficiaries of the estate. The problem was that there was an earlier will document that included family members, and then there was a subsequent will document executed when she lacked the ability to understand what she was signing, and certain family members were cut out.
Okay.
Those family members reached out to us. We were able to establish that, in fact, she did not have the capacity to sign that document, the effect of which was that the judge struck the document and reinstated the prior will so that all family members participated.
So we won.
We won.
Our client won, and that's not a small undertaking, in the sense that it's my understanding that judges will give great weight to the document that is probated, to the will, to the instrument. They give great weight. They don't want to just allow that to be disregarded.
You're right. The written words of the decedent are of primary importance to the hearing judges, and you really have to provide them with significant evidence to sway and affect their ruling.
So, folks, if you've got a will that you believe somebody was forced to sign, that was against their will, that they lacked the capacity to understand what they were signing, it can be struck. But it isn't your words and testimony alone that will carry that day. You actually had doctors. You had medical testimony.
Yeah, we needed the medical testimony from the decedent's treating physicians, which was more than adequate under the circumstances.
So how do we get retained for a matter like that? Because this isn't done on a percentage of the recovery.
No, that's done on an hourly basis, depending on what the legal problem is. Our clients sit down with us. We inform them as to what the hourly billing is going to be. We do request a retainer up front, and then we apply the retainer to the work to be done, and we bill once the retainer is exhausted.
And sometimes, folks, that includes, the fees and costs of litigation for these types of cases have to include expert testimony and other costs that we have to pay in order to bring that evidence into the courtroom.
That's right.
It isn't an inexpensive undertaking.
No, depending on who the doctors are, we're guided by the doctor's demands as far as what they believe their time is worth. And if we want to proceed successfully, their services have to be retained.
All right, let's take a caller. Let's talk to Dorothy from Willingboro, New Jersey, a town I happen to know well, one of the few towns in Jersey that actually I find myself going to occasionally. But, most of the towns in Jersey aren't worth going to, but Willingboro actually is a nice place. Yeah. Now I have 92% of New Jersey right now ready to strangle me. What's wrong with my town? What's wrong with Cinnaminson? What's wrong with Pennsauken? No, I'm just kidding. Sit back and relax. Dorothy, good morning.
Good morning.
How are you?
Okay.
So,
now my question, yes.
Go ahead. Your question.
My question has to do with, I have brothers whose wife died, and she was the person responsible for her mother's house and her mother's, she was like the guardianship person. And then she passed away, and the deed was in her name and her mother's name. So
is the mom wife, is your sister-in-law's mom passed already?
She just passed as well.
Before or after the sister-in-law?
The sister-in-law died first.
Okay.
Now,
so sister-in-law dies, and the home that was in the name of sister-in-law and mom then becomes the sole property of mom.
You have to take a close look at the deed to see the language of the deed, which will spell out how those interests are to be shared.
Okay, but go ahead and get on.
Mom died.
So then mom dies. So then what's the question?
So now the question is, the grandson had the guardianship over would have been his grandmom.
Right.
And so once she died, he no longer had that status. So we are not able to get our hands on the will to find out when both parties die, how do you get this resolved?
Okay. So who's the beneficiaries of the grandmom? It would be her children. Are any of her children alive?
Well, we're talking the grandmother?
Yes.
The mother?
Yes, the mother.
Mm-hmm. Mm-hmm. She only had the one daughter, and the one daughter died before she died, and that's whose other name was on the deed.
Okay. And so there's no children. How about grandchildren?
She had two grandsons who was fiduciary or whatever over her. He was making sure her bills was paid while she was alive. So now that she died, she had the two grandsons.
Right, but if there's a will document, the will would name an administrator of the estate. That person...
Well, that's the problem. We don't know how to get the will. The grandson is not being cooperative, and we can't get our hands on the will. We can't get any of this information to find out how to get the will.
Well, it's not a public document, is it, Saul?
It's not a public document until it's probated, assuming there's a will.
Right. What if there's not a will?
If there's not a will, then the distribution of the estate will pass according to the intestate statute.
Which in this case would probably, if there's only two grandchildren, would go equally to each of the two grandchildren.
That's correct.
But she had a sister that the grandchildren will override if she had a sister or if she had siblings.
Correct. Yeah, direct lineal heirs, children, then grandchildren, and only getting into siblings if there are no direct lineal heirs.
Okay.
And that's if there's no will. Now, if there is a will, she could choose whoever she wants. But again, if the will would have to be probated, it would have to be filed in the county in which she resided when she passed, probably. Where did she reside? Burlington County?
New Jersey.
Which county?
Mercer County.
Huh?
Mercer County.
Mercer. Okay, so if you went to the Mercer County Register of Wills,
Circuit Court,
in the circuit court, you would find whether or not a will had been probated.
Mm-hmm.
So if an estate is raised under her name, that's where it's going to be. If it's not yet raised, then one needs to be raised, and either of the grandchildren can raise that estate. So you don't have to rely upon or wait for one grandson to do that. If the other one wants to go raise an estate and it hasn't yet been raised, he can begin that process.
Mm-hmm. So, but what if you can get the death certificate? That's illegal.
Yes.
You can just go and get a death certificate.
Absolutely. Yes. And that's what you need to start the process. And if you don't have a will, then you're probating it as
administration.
Yeah, and it's an administration, but an intestate estate. That's what I was thinking of. There's a testate estate, which is one with a will, and an intestate estate, which is one without a will. And so the grandson could go forth with a death certificate and state to the county clerk that he's not aware that a will exists. Now, if an estate's already raised, they'll let him know that. Oh, no, there's one already raised, and it's right here. And then you'll get some more information. Dorothy, these things aren't easy. I think that's the important point, what you raise here. You have to, and it's something I wanted to talk to Saul about anyway. But Dorothy, I hope I answered your questions to the best of my ability today.
Thank you. Yes, you did.
All right. Take care. Saul, the point Dorothy brings up is this isn't easy stuff for individuals to do.
She brings up a very good point. It's actually an issue that cropped up twice this past week where radio listeners spoke with me during the week, and they were expressing concern about the existence of an estate, the existence of a will document. And in one instance, I actually called over to the Register of Wills and confirmed that an estate was raised, and the client was instructed to go into City Hall to go over to the Register of Wills office and photocopy all of the documents in the estate file, which she did do and brought to me, and that answered a multitude of questions.
So, folks, if you've got legal issues regarding estates and you feel like you're in a quandary, you can't really get to the bottom of it, you can start by giving us a call during the week. Saul will be happy to walk you through what we can. All you got to do is give us a call at 215-227-2727. Let's talk to Nikki from Seacane on line 2. Hi, Nikki.
Hi, how are you?
I'm wonderful, thanks. Is this the first time you're calling us?
It is.
Well, listen, I want you to stay on the line when we're all done, and Monica's going to get some information, and we're going to get you a Court Radio T-shirt for being a first-time caller.
Okay.
See,
All right.
I reward my listeners. So, you have a question about a trust?
Well, I'm not sure if it's a trust or a will that my husband and I should start to think about. We have 2 children, and one is disabled. He's on the autism spectrum. And we just want to be prepared because we started having children later in life that if we or when we pass away, that we have things in order for him, for his care. But
Right.
we're not sure what his care may be, what it may need to be when he is an adult. But if he can't take care of himself, wanted to have something in place so that he could be taken care of comfortably.
There's a lot to consider. How old's your other child right now?
He's 2.
Okay. So you have young children and you have a disabled child, and I would say a trust is probably vital at this point because, while we don't, we're not planning for this to happen, but God forbid, if you and your husband were to pass in the near future from some catastrophic accident, that's really why you need a trust now, because the money needs to be cultivated, protected, and dispersed to the children when they're able to handle it later in life. You don't want to give money to a 2-year-old. Go ahead, Saul.
You touch on a very delicate topic. There's a collection of special needs trusts. These special needs trusts are earmarked for certain types of fact patterns, and you've identified one of the fact patterns, but a special needs trust would not necessarily apply to yourself, your husband, or your other child. So it takes some detailed planning depending on what you're hoping to accomplish. But you are correct in that planning for a special needs child is something that you should be doing as quickly as possible.
And sometimes, I just want to turn my earphones down. Saul's knee is going to have blood coming out of my ears in a second. Sometimes you don't want to give money to a special needs child because you don't want it to create a scenario where you deprive them of the benefits, the social benefits that they might be entitled to, the social programs that they may be entitled to for, free medical care or what have you. So it is complicated. It needs to be kind of teased out and understood. And a lot will depend on the value or size of your estate. If your estate's, $17 million, it might be handled one way. If your estate's $100,000, it could be handled a different way. So there's and that changes over time, right? Like your estate isn't fixed where it is today, presuming it grows. So you want to keep coming back and every few years and making sure that the documents still make sense when you create these documents. Wouldn't you say that?
That's true.
Yeah. So, but at this point in time, I would say you need a will and a trust, both, and then go from there. But stay on the line. Monica's going to grab your address, and I want to thank you for giving us a call and giving us a shot to talk to you.
Thank you so much for your time.
All right, hold on. Folks, we got wills, estates, trusts, and I've got some other callers with other questions. We're going to come back to everybody in 2 minutes.
You were just hurt. It's not your fault. You're in physical pain. How do you get better? Who is going to help you recover? West Philadelphia Associates has highly trained doctors and staff that can help you today. Don't wait at a hospital. West Philadelphia Associates will work with your attorney, providing documentation of all injuries and the best plan for treatment to get you back to the life you deserve. With diagnostic studies to better detect injuries, West Philadelphia Associates doctors and staff will help you recover. West Philadelphia Associates, here to help you get better because you deserve it. Call 215-471-4714.
For 20 years, Center City Medical Center has provided premium expert medical services for Philadelphia. Whether you need musculoskeletal rehab or an immigration physical, call 888-945-EXAM. Our board-certified physicians have more than 80 years' experience from post-injury rehab to DNA paternity testing. To make an appointment at one of our 3 convenient locations, call 888-945-EXAM. Get premium expert care. Center City Medical Center, serving Northeast, North, and Center City, Philadelphia. If you've been injured on the job and are entitled to workers' comp, you need someone fighting for you from the start. Call Jeffrey Gross, attorney at law. Don't rely on your employer or insurance company to get it right. Call 215-512-1000 215-512-1500. If you're entitled to workers' comp or it's being challenged, Jeffrey Gross can help get the money you deserve, and he won't get paid unless you get paid. Call 215-512-1500. Jeffrey Gross, attorney at law, representing Pennsylvania's injured workers for more than 20 years.
If you've been injured, the road to recovery can seem long. At United Therapy Centers, we're here to help. Call us 877-510-7764. With leading-edge technology and our team approach, we provide the highest level of patient care with a pain management program developed just for you. If you've been injured, we can help. Call United Therapy Centers toll-free 877-510-7764. United Therapy Centers, get on the road to recovery.
The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Need more legal answers? Here's more Court Radio with your host, Dean Weitzman.
Hey, welcome back. It's Dean Weitzman, and this is Court Radio. I'm joined in the studio with my special co-host. You know him as Just Call Saul Ransom.
Good morning to everyone.
Hey! Whenever I don't have an answer for a question, I usually tell our listeners to call Monday morning and ask for Saul. And we got social media issues. So if you want to follow us, all you got to do is follow us on Twitter at Court Radio. You know, my friend Shannon Spector just followed us. He's probably driving around listening right now. I want him in this studio soon. But he's obviously smarter than me when it comes to social media because I'm kind of incapacitated with regard to social media. But I was told if you do at Court Radio on Twitter, you're going to get our Twitter feed, and Monica tweets like nobody's business. All right, that job is done. Let me ask you something, Saul. When somebody needs to have a will done quickly, how quick is quick when it comes to My Philly Lawyer?
We have created the will documents the very same day.
So somebody can actually come in on at an appointment and leave with a will in hand.
There have been instances recently where that has happened.
What happens, when we anticipate the possibility of a will contest? What can we do to alleviate that problem?
We have we can give our clients certain options, and one option which has proven to be very effective is we invite the client into our video conference room. We are set up with all of the video equipment, and we will have the client recite his or her wishes verbally, and her wishes are recorded. So there's actually a CD of that conversation, and those exact words are then incorporated into a will document. So if somebody disgruntled member of her family or his family should challenge that, and they challenge it on a mental capacity basis, you have one up on that individual because you have an opportunity to observe the demeanor of that individual leading up to the preparation of their will document.
How cool is that? So you leave with a will and a DVD of yourself showing the world after you've passed that you knew what you were doing all along. That's obviously an additional cost.
It is an additional cost, yes.
Okay. 215-227-2727. Let's talk to Charles from Strawberry Mansion.
Hello, Dean.
Hello, Charles.
How you doing, sir? Yeah, this is my name is I'm Charles, and I'm from Strawberry Mansion. I have a problem. My problem is I'm a special needs. I have a special needs trust person.
Okay.
And I don't have a will. Yeah, hello.
Charles, turn your radio down. You got that?
I can't do that.
Okay.
I have a spine injury.
I see.
I have to wait for my aide to come.
Okay.
Sorry for the trouble.
All right. Well,
You just bear with me.
that's all right. So all right. So you're at home. You don't get around easily. You need a will. What would we do for somebody like Charles, Saul?
Well, there are instances where we are able to create the document without the client coming in. We can gather the necessary information by telephone. We can prepare a document. We can also prepare a letter of instructions, and hopefully that individual has an assistant or family member available to them who could follow our written instructions and assist them in the execution of the will document.
Right, because Charles, the easy part of this is you communicate with us over the phone, tell us what it is, or who you want to leave your property to, and what property you want to leave, and we record that, and we create a set of documents, the will primarily, that effectively undertakes your wishes. The tricky part is the easy part, I guess, or the tricky part is signing it at the right place. Because what happens, Saul, if you don't have the right witnesses signing it in the right location or the signatures aren't right, what happens to the will?
Well, there are very specific legal requirements in order for these documents to be probated. And if you do not comply with these requirements, we had a situation very recently where the witnesses to the will document, the witnesses did not sign their names in cursive. They block printed their names, which disqualified the will.
Wow. And once the will's disqualified, then you're under the intestate statute. And what does that mean?
If you're under the intestate statute, then the legislature has devised a scheme of distribution. The legislature is telling us that if you have no will document, there's a pecking order of which family members are next to receive.
Okay. And so it may not be the person or people you wanted to receive your property under your will.
That's absolutely correct, and that's the reason why we encourage all of our radio listeners and our clients to don't think about it, but reduce your thoughts to writing in the form of a will document, because in our firm, we only charge $250 for a simple will.
Right. So it's quick, it's inexpensive, it's easy. There's really no reason why you wouldn't at least start with a simple will so that your wishes are recorded. Because, again, you may not want your property to be devised according to the statute.
The purpose for the will document is to take a snapshot of your needs today. You can't project too far into the future. If you create that will document and it satisfies your needs today, then you've accomplished the job. If something should change in the near future and you need an amendment, an addendum, something to tweak that document because you're changing beneficiaries, it's very easy. It's one telephone call away.
All right. Let's talk to Eric from Overbrook on line 3. Eric, you've been so patient. How are you, sir?
I'm going fine. How about yourself?
We're all good here. We're all good. So, Eric, you're not calling about wills and estates. You got no needs for wills and estates. What's your question?
Not right now. my question is this. I own a 2013 Nissan Altima.
Uh-huh.
I bought the Altima at 29,000 miles. Okay, I put 72,000 miles on it, and the transmission went bad, which made it out of the factory warranty at 60,000 miles. I was not aware of pre-certification because it never dawned on me. You know, when you buy new cars, you figure all that come with the car to be pre-certified and all that, which I was wrong. Our motor dealer told me that I should have had a pre-certification for 100,000 miles because they do all their vehicles. Okay, I didn't get it from Armour. I got it from somebody else, which made it two different policies. Okay, they wanted to charge me $3,600 to put this transmission in, right? So I found out researching that those transmissions was bad, and one was put in at 26,000 miles, which I was not aware of. So they dropped the price to $2,400. So I called the factory to see if they could also add to my problem, my situation, being though it still wasn't 60,000 miles on the car. But they're saying they go by the car, the actual car mileage, and not the time that the second transmission was put in.
Right.
So I said, why should two transmissions have to be put in a car in less than 2 years? That should indicate something. But yet they still
you bring up a good point, and that is, and I've seen similar scenarios to this, and that is, we're not car experts. Though we like to think of ourselves as car experts, we're not. And so if you wanted to make a claim that transmission was in some fashion defective, you would need an expert on transmissions to look at it and to render that opinion. With that opinion by an expert that the transmission that went bad in whatever 40-some thousand miles that had been installed at 26,000 was defective, then I think you have a little bit stronger of a case. Otherwise, without that, I believe they are correct in their position at this point. But with an expert opinion otherwise, you probably see the factory's story change. So that's my thoughts on that. Eric, take care. Thanks for calling Core Radio. Keep on listening. 215-227-2727. Let's talk to Mike from Newcastle, as in Delaware, that little itty-bitty state to our south.
That's correct.
There you go. Hi, Mike. How are you?
Oh, pretty good. How about yourself?
I'm wonderful. Yeah. It's always good to have Saul come in and bring his knowledge of wills and estates for our guests. What's your question?
My question is, my wife and I, we're remarried, but we both have kids from our previous marriages. And we got a house that's worth, I don't really want to say the amount, it's worth a lot. And my question is, if something was to happen, because we have kids, we both have kids from previous marriages, if something was to happen, can any of the kids come after anything that we both have? Like, can her kids come after what she has if she was to die?
Okay. This is a really interesting. Turn the radio down first of all, but it's a really interesting question and a common question or a common problem nowadays. And I really think it depends on who dies first. But I'm going to let Saul take a shot here.
A child does not have a legal right to any of that child's parents' assets, so that a parent can leave to whoever he or she wants. If a parent passes away and doesn't leave a will document, and the parent in their name owns property and they have natural children, those natural children under the intestate statute would have a claim. But there is no legal claim where you can sue an estate unless it's under the intestate statute.
So the first thing is, do you guys have a will?
Well, not at this time. We were working on it.
Okay.
We haven't completed it yet.
So if you have no will, and let's paint the scenario that Mike dies first. Well, all the property that you and your spouse own would then, I presume, become the property of the spouse.
That's what I was hoping.
Okay. Mm-hmm. So nobody has no children have a right greater than your spouse. She would take the property. Now the question is, she passes, okay? Your children then wouldn't get anything. Her children would, because the property, by the time she passes, is hers, not yours any longer.
Got you.
So that's why these scenarios pose interesting questions. And what you and your spouse need to do is sit down and figure out exactly how you'd like to see the property be disposed of upon the death of the first and then upon the death of the second. But
we kind of did, but we just haven't submitted it yet.
Yeah, well, yeah. You know what happens when that happens is that there's usually, it never gets submitted.
Well, this is a perfect example of why you should reduce your thoughts into writing called a will.
Okay.
Yeah.
Okay.
And the interesting thing here, though, is, like, you know, I've thought about this, and Mike and his spouse decide that they want to treat all of their children equally. And so they create a will document that says that when the first of them passes, it goes to the survivor. But when the survivor passes, it goes to equally to the 4 children, 2 from each side. But what is to stop the survivor from recreating that will after the first dies?
Nothing.
Okay.
Nothing. There's the surviving spouse is not bound by the language in the old will document. The surviving spouse has the freedom to create a new will document and identify who the beneficiaries are supposed to be.
And that's always the interesting thing when it comes. Now, you can get very complicated here, and you can create trusts and give spouses a life estate, and then they have it, but it's, you know, it's she doesn't really own it because she has a life estate, which allows her to live in it while she's alive, but not disperse it. And this is far beyond a simple will. But again, it can we can create documents that will accomplish whatever you want.
In fact, we just did that a couple of weeks ago. We created a deed. We prepared a deed for a woman who left her home to her 2 children, but gave a life estate to her live-in boyfriend.
There you go.
Wow.
So you will not stump us, Mike from Newcastle, but we look forward to the challenge. Give us a call during the week at 215-227-2727, where all the magic happens. Take care, Michael. All right, folks, we got to pay the bills, so we're going to take one more break for 2 minutes, and we'll come right back to your questions in 120 seconds.
If you've been in a car, truck, or motorcycle accident, you know what matters. Being able to afford medical care, providing for your family while you're out of work, knowing your rights, and getting just compensation. These things matter. That's why your attorney matters. I'm Dean Weitzman. If you've been injured in a motor vehicle accident, My Philly Lawyer will fight for you. Call 215-227-2727. My Philly Lawyer, when winning matters most. If you or a loved one has been the victim of a medical mistake or misdiagnosis, you know what matters. Getting proper care matters. Providing for your family matters. Your attorney matters. I'm Dean Weitzman. For more than 30 years, My Philly Lawyer has been holding hospitals and insurance companies accountable for medical errors. Let us fight for you. Call 215-227-2727. My Philly Lawyer, when winning matters most.
If you have legal problems and need answers, call My Philly Lawyer's Dean Weitzman first at 215-227-2727. Whether it's personal injury, medical malpractice, birth injury, or more, Dean is ready to fight for you and the compensation you deserve.
I'm Dean Weitzman. Facing any kind of legal or medical challenge can be overwhelming, but you don't have to go it alone. Call 215-227-2727. My Philly Lawyer, when winning matters most.
You were just hurt. It's not your fault. You're in physical pain. How do you get better? Who is going to help you recover? West Philadelphia Associates has highly trained doctors and staff that can help you today. Don't wait at a hospital. West Philadelphia Associates will work with your attorney, providing documentation of all injuries and the best plan for treatment to get you back to the life you deserve. With diagnostic studies to better detect injuries, West Philadelphia Associates doctors and staff will help you recover. West Philadelphia Associates, here to help you get better because you deserve it. Call 215-471-4714.
The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Need more legal answers? Here's more Court Radio with your host, Dean Weitzman.
Good morning and welcome back. Thanks for listening. It's Dean Weitzman, and this is Court Radio. I'm joined in the studio with, you know him as Just Call Saul Langsam. Hello, Saul.
Good morning, everybody.
Whenever I can't answer a question, I usually pass the baton to Saul because he's seen it all and heard it all. So we got callers coming out, but let me just tackle Michael from Northeast Philly on line 5, who's been so patient. Hi, Michael. Welcome to Court Radio.
Yes, hi. Good morning. How are you?
We're doing well, thanks. Where are you in Northeast Philly?
Around Rising Sun and Godfrey Avenue.
Ah, I know it well. Yep.
Yeah.
All right. So what's your question?
Okay, my question is, back in around 2006, I believe it was, my mother, she had the transvaginal mesh put in because she had a hysterectomy.
Okay.
Okay. In 2010, that mesh had started, eating through her insides, not her kidneys, but her kidneys and her intestines, I believe it was.
Okay.
And she passed away. Okay, prior to that, she was in the hospital back and forth.
Whoa, Michael. Let me just ask you a question. When did Mom pass?
In 2010.
Okay. So the statute of limitations for a wrongful death, if the mesh were the cause of her death, we don't know that for sure, but let's presume it was. If the mesh were the cause of her death, she has 2 years, her estate has 2 years from the time of her death to bring an action against whoever was responsible for causing her death. Unfortunately, that 2-year period is long gone.
Yeah, and that's what happened too. She was in the hospital, and they're the ones that told us that's what the cause of death was.
Okay.
And soon after that, it wasn't 2 years. It was not even a year. I had retained a lawyer down on Walnut Street. I forgot his name, about this. And I never seen the records from the hospital that she was in. And the cause of death, but they had told my sister because in 2010 I also had a kidney pancreas transplant. So she passed away while I was recovering from the transplant. Okay, all of this information was given to my sister of the reason she passed away was because of the transvaginal mesh that had started pushing into her insides. Okay, as soon as I learned that, that's when I got the lawyer.
Okay.
I was referred to a lawyer, and they looked over the records and stuff.
Right.
And
they concluded.
They concluded that the hospital wasn't the cause of, the hospital that she was in.
Right. It
wasn't their fault that this happened to her.
Okay.
But and it wasn't nothing that we could do, So, but the mesh was put in by another hospital that did the hysterectomy. And like you said, and they told me that I had 2 years also.
Right.
But
and so
I always had a gut feeling that something wasn't right with this whole scenario here.
And a lot of times you got to go with your gut, and keep exploring it. The problem here is that didn't happen, and there may have been a claim, but time is now barring that claim. And even a valid claim that is time barred due to the statute of limitations is gone. And so that's the lesson is that we can't sit around and wait. If we believe in our cause, we have to keep on keeping on, because once that 2-year period has run, there's nothing you can do about it. usually. I can't ever say never, because if there were fraud or something of that nature that prevented you from pursuing it, there are reasons why the statute can be extended. But you've presented nothing to me that would indicate that this statute is extended. So in any event, thank you for calling Core Radio. Have a great Sunday. Let's take another caller before we run out of time. How about is this Katrina from West Oak Lane? Is that right? Did I get that right, Katrina?
Yes, hi, I'm on the line. Yes, good morning. How are you?
Good. We're almost out of time, but I figured, we got a little bit left. What's your question?
Yeah, I have a quick question. My mother passed on March of this year, March 22nd, and she did have a will. We were trying to find the will, but I didn't actually find it until after she passed. Now, she did leave me her property. I went down to City Hall, and I did the probate deed for her property, but now I just got some mail in the mail about a couple of weeks ago saying that she owes about $8,000 or $9,000 in outstanding hospital, medical bills. So my question is, I want to actually do the final transfer because I know I don't have to pay the inheritance fee because she has a will. But I'm thinking now, does that money have to be paid in full before I can do the final transfer for the house now, or can I still do it?
Okay. Well, I'm so glad we got to your call, because Saul wanted to talk about this. He's been chomping at the bit to talk about how individuals can get themselves all jammed up because they don't know how to really conclude an estate and how to handle valid claims. So go ahead, Saul.
You raise an excellent point. The problem is that probating a will and opening the estate, that's the easy part of it. What the public does not understand, because it's not made clear over at the Register of Wills, is you really need legal representation to deal with all of the paperwork associated with closing the estate. Now, you made a statement that there's no inheritance tax. That might very well be. In Pennsylvania, there is a 4.5% inheritance tax between a parent and a child, and that's based on a net positive estate. Now, I have no idea whether the debts of your mother's estate exceed the value of mom's estate. If there are more debts than there are valuable assets, then you may be correct that there's no inheritance tax. But the public leaves themselves open for a multitude of problems, because if you haven't filed the inheritance tax return, it's going to create a lien on the real estate that you've inherited. These are some very complicated issues that require legal representation, and it's not until there's a problem with a client calling me from the settlement table saying the title company wants to escrow for inheritance taxes when my mother died, that they begin to seek the services of an attorney. That's when it's late. You should do it much earlier than that.
So there may be inheritance taxes. You must file a final inheritance tax return. You must file a final inventory. You must pay a tax to the city of Philadelphia for that final value of the inventory. And yes, your mom's final medical expenses are valid bills of the estate, and the hospital could reach out and grab a piece of your property even after you transfer it if you don't handle that now. And they're all, by the way, they're all negotiable, but probably not by you. But a professional can call the hospital and negotiate those bills from 8 to 2 or something like of that nature. It's why it's so important for folks not to go it alone in these instances.
Quick question is, now, if I had transferred, if we had taken care of all of that before she had passed, would they still be able to come after the estate since it would be in my name, or how would that head?
Well, I'm not exactly sure what you mean when you say we took care of it before she passed. And unfortunately, I'm eating into somebody else's time. Okay. We have to go, but give us a call during the week, 215-227-2727. Saul will be happy to meet with you. Folks, thanks for listening to Court Radio. Saul, thanks for participating.
Always a pleasure, Dean.
All right. See you next time.
Bye-bye. Thank you.
Bye-bye.
The preceding